Hi, y'all, and welcome to tonight's live stream. Can anybody be fair to Chad Daybell? He's accused of some of the most heinous, frightening crimes imaginable. Murder of a 7-year-old autistic boy, J.J. Vallow. Murder of a 16-year-old girl, Tylee Ryan. And even the murder of his own wife of 29 years, Tami. He's also charged not just with murder, but with conspiring with other people to murder them and with insurance fraud related to his wife Tami's murder. Now, on the first 2 days of Chad Daybell's trial, prosecutors, Chad's lawyer, and the court have been on a hunt to find 18 people who have not prejudged Chad Daybell and can still be fair and can sit through an 8 to 10 week long trial and who are willing to be open-minded about the death penalty. But it is a nightmare of a task in a case this horrific and this well-known. Last year, we covered the trial of Lori Vallow Daybell, who was convicted of the same crimes Chad is charged with, slightly different. Lori is Chad's current wife. Lori and Chad married just a little over 2 weeks after Tami Daybell mysteriously and suddenly died. Finding a jury for Lori was hard, but she was convicted on every count last year, and there was a great deal of publicity about her trial. That makes finding a jury in Chad's case even more difficult. Tonight, we're going to talk about what's happening at the trial, which started yesterday, and why jury selection is so hard in this case. I am so glad to have you. This is a bonus Tuesday live stream. We normally go Monday, Wednesday, and Friday at 7 p.m. Eastern. So this is extra. There are just so many cases we're covering right now. I just needed an extra to kind of fit everything in. So if you would, please hit the like button for the video. Subscribe. We would love to have you come back. And I want to say a special shout out to the first 5 in the chat tonight: Forever Red, Elizabeth, Veronica Lass, Armchair Apothecary, and Cindy Johnson. So special shout out and welcome to y'all. So tonight we're going to cover 3 topics or areas. The first is going to be, why do you care if Chad Daybell gets a fair trial? The second is going to be how jury selection is working, what's actually happening at the trial. And the third is going to be why it is just a nightmare of a situation to try to find this fair jury. And let me start with a question. I often get comments like, well, what do we care if he has a fair trial? I mean, he's guilty. We all know he's guilty. And it's really easy to think, who cares if Chad Daybell gets a fair jury? Maybe you heard the evidence against Lori Vallow Daybell and you think, the guy's guilty as sin. Why should he get a fair trial? And I want to give you 2 reasons why he should still get a fair trial. The first is sort of bigger picture, broader. And that's that as Americans, we want to live in a country and with a justice system where people get fair trials. I mean, that's just a good thing. Just in general, our system depends on that. It's part of who we are, and I think who we should be as a country. But there's a second practical reason. Forget that if you didn't even believe that or buy that. If you think Chad Daybell is really, really guilty, then you especially want him to get a fair jury. And here's why. He does not get a fair trial for any reason, including selection of the jury. It is far more likely that the case will be reversed and that the whole trial will have to happen again. That's not good for anybody. It's especially the families of the victims, number one. And then it's also not good for taxpayers, for example, who are footing a hefty bill for the trial. But so for all of those reasons, even if you think Chad Daybell is really, really guilty, it's important that he get a fair trial and that this be a trial that will stand up on appeal. But how? How do you get somebody like Chad Daybell a fair trial? So let's start with how the jury selection is working and talk through kind of what's happening during this process. So the issue with the case is it's so notorious and well known that it's very difficult to find jurors who don't already have an idea about how they feel about the case. So the court has called in a massive group of jurors. I believe I read that there are a total of 600 called in, but I haven't been able to find that number again, so I'm not exactly sure how many they called in. Before trial even started, the court did a couple of things to try to smooth the process. The first thing is the jurors are filling out questionnaires. And so now, as each group is brought in for the process of asking them questions, the attorneys and the judge already have answers to some key questions about them. The jurors are then interviewed in a process that's called voir dire or voir dire, depending on what part of the country you're from. I'm going to straddle that fence because people feel very strongly about how they say that. And depending on what part of the country you're from, you may say it differently. But in a smaller case, the court might do voir dire. I'm giving away my prejudice. That's how they say it around here. Might do voir dire with every single juror all at once. But the number of jurors for this case is just too many for that. The judge can't really do that. So what the court is doing is calling groups of 16 at a time. And initially, the entire group is asked questions. And then the individual jurors are asked questions. And the judge and the prosecutor and Chad Daybell's attorney, John Pryor, all get to ask questions. As they go through and talk to the jurors, both sides will sometimes ask the judge to dismiss a juror for cause. That means for some reason, the side that's asking believes that there is a legal reason or a practical reason why this juror should not be on the jury. And we are going to talk about what some of those reasons are. We're going to go through that. Sometimes the parties will agree that a juror just should be removed. Sometimes they'll disagree. Either way, the court has to grant the motion and dismiss the juror or keep the juror on and say, deny the motion and say, no, I think this juror can serve fairly. So the judge is going to keep going through this process, keep calling in groups of 16 until he gets 50 potential jurors. And then each party will get 16 peremptory challenges or strikes, as I'm used to calling it, and will get to remove jurors they don't want on the jury out of that. So the court is aiming for 18 jurors. There will be 12 who will sit on the jury, and then there will be 6 alternates, which is a really important thing in a case, a trial as long as this one. It's expected to go 8 to 10 weeks, which is really long. And inevitably, some jurors just have to drop out along the way. Somebody gets sick, a family member gets sick, somebody has some family emergency. There are just things that happen along the way. So the court says he wants to keep calling those groups of 16 until they get 50 eligible jurors. That way he's got 18, 12 jurors, 6 alternates, plus enough for both sides to have 16 challenges, plus a couple left over because that only takes you to 48. I guess an extra 2 just for good measure. So trust me when I say that when you're an attorney, there are never enough strikes to get all of the jurors off that you are worried about. So attorneys try very hard to get the judge to strike the jurors they're worried about for cause, because that's a free way to get somebody off the jury. You can save your peremptory challenges because of those strikes, you hoard them like they're gold. And then when the time comes for you to actually use your strikes, your peremptory challenges, you can strike any of the jurors that you want to, sort of. Let me pull back on that a little bit, because for example, you could strike somebody because you didn't like the way they looked at the client, or you think the way they dress suggests that they're going to vote against your client. It's a real button-up businessman versus your client who's sort of bohemian and very young, or maybe you didn't like the way the person hesitated before they answered a certain question. You can strike jurors for any reason, except there are some limits. After a 1986 Supreme Court case called Batson v. Kentucky, the court limited strikes for certain reasons. Attorneys cannot strike a juror just because of the juror's race or just because of the juror's gender. So during the process, when the lawyers use their strikes, sometimes the other side will make what's called a Batson challenge. And they'll say, hey, I think that side is striking the juror for an inappropriate reason. They're doing it for race, they're doing it for gender. And then the lawyer who was trying to strike that juror has to be able to articulate a good reason that is neutral. In other words, it's not just because of race or not just because of gender. So at this point in the Chad Daybell trial, the judge and the lawyers worked all day yesterday and a half day today, and they worked their way through 3 groups of 16 jurors. And technically today, 2 jurors didn't show up in time, so it was only 14 jurors. After day 1, there were 16 jurors who were potentially eligible. 16, let me say it this way, 16 people potentially eligible to serve on the jury. And then after today, there were an additional 4 added to that group. So at this point, the court has found 20 of the 50 it's trying to get to. It seems pretty likely at that pace that jury selection will go all week, maybe possibly even longer, and that opening statements will be something like the first half of next week. So now I want to talk about why it's a nightmare, why it is so very, very hard to seat a jury in this particular case, why they had to call in hundreds of jurors, why this is taking a full week, which is very long. Most trials take less than a week, and just jury selection is going to take a week in this case. So I'm going to refer back during this part of what I'm going to be talking about to some clips I did. Back when we were covering the Lori Vallow Daybell trial, during her jury selection, I interviewed an attorney, Betty Duncombe, a Harvard Law School graduate and a jury consultant, and asked her some of the questions about, I asked y'all for suggestions of questions, and I interviewed her and asked your questions and my questions so we could get a little better idea of what a jury consultant would say. What are the things the parties should look for, are looking for, what would make for a fair juror, what are the things that are going to make it difficult? So I asked her about those. So I'm going to weave some little clips from that into what I'm going to talk about tonight, because although definitely what she said is still valuable and useful, there are some changes because of the fact that Lori Vallow Daybell's trial has happened now. So there is more to think about and to deal with than there was back when I interviewed her. So one of the key problems for the court and for the parties is availability. This trial is a mega long 8 to 10 weeks. That's 8 to 10 weeks that people can't work their regular jobs, or if they maybe are self-employed, then they have to try to work at night, late at night, and then come in and try to pay attention all day the next day and then go home at night and work again. It's exhausting. And maybe they can't drop the kids off at school, kind of depending on schedules. It's the end of the school year by the time this finishes. Maybe they can't go to field day or the end of the year school performance or school party with the kids. There are things like that that are going to be missed. Now, most trials are a few days, maybe a week. This is different. So availability is a problem. People have trips planned, surgeries, weddings. They may not be available for any number of reasons. And in addition to that, many of the jurors have asked to get out because of the second reason that's made this difficult, which is just hardship. Even if they're in town, even if they're technically available, it could be very difficult for them to serve on the juror. So these jurors are paid a very low amount. One of the things I read was they get about $80 a day for the first 5 days, and I think $10 more after that. If you are giving up your regular job and you're not going to be paid, that's not going to make up for what you're losing, most probably. Furthermore, since this is a death penalty case, if the jurors find Chad Daybell guilty, they will be sequestered for what could be a couple of weeks. That means, when I say sequestered, that means they're going to be kept together at a hotel. They will not be allowed to go home, not allowed to access the internet, probably won't be allowed to see their families. There might be some arrangement for that, but they will be put all together so that there's no possibility of any outside influence that would get in the way of them reaching a verdict together fairly based on only what they see in the courtroom. This is a death penalty case, so it's treated with great care, and particularly during that phase. So obviously restrictions like that could cause a significant problem for a lot of people. And many of the jurors have talked about the problems that serving on the jury could create for their jobs and for their income. One juror mentioned starting a new job 5 weeks ago and said, well, I won't be paid. I'm not going to get fired, but I won't get paid. And everybody agreed, and the judge dismissed that juror. There was another juror who said her husband was going to be losing his job in May, and she would be the sole income support for the family, and it would make her very anxious, hard to pay attention if she were asked to serve as a juror. She was dismissed. There was a student who said, I'll be missing classes, and also I work full time. If I can't do that, I'm not going to be able to pay rent. I'm going to lose my apartment. So everybody agreed, and that person was dismissed. A musician said, look, I work weekends, Thursday through Sunday. I go travel out of town. That's my job, and I can't really miss that. So everybody agreed, and that juror was dismissed. One juror said they had medical appointments for migraine shots. They had to and would have to wait 3 months for another appointment. And there were medical appointments for her daughter. Everybody agreed, and that person was dismissed. There were all kinds of different reasons why people said they couldn't serve. One thought his wife might have to travel to be with a family member who had stage 4 cancer. And there, many people were dismissed for that, but not one police officer. I'll tell you sort of the little story about how that worked. For this police officer, he mentioned that he was concerned about having issues with child care, and also we started with some shortages that might be caused at work with staffing if he wasn't available and able to staff his normal shift. So the state moved to excuse him, but the judge said no. And I think one of the reasons is a police officer of all people should understand how important it is to have those jurors there in the courtrooms. That's probably what it was. That would be bad news for Chad. We will talk about that a little bit later on, why police officers, law enforcement officials would not be high on his list of the people that he would want to be on the jury. So we'll talk about that. The third reason why this is so difficult is it's a death penalty case. That complicates absolutely everything, including jury selection. The prosecution is entitled to find out and to exclude jurors who will not absolutely refuse to consider the death penalty, no matter what. And some potential jurors have been dismissed for that reason. And here I want to play you a little clip about what Betty Duncombe said. She talked about the way to get the jurors in a death penalty case is don't look at stereotypes, which is kind of tempting to look at stereotypes like gender, but instead try to find out about the individual jurors' beliefs. So let me add.
Have a death penalty case. Typically the jury will decide guilt or innocence, and then they will make a separate recommendation as to the death penalty. And when you go through that, it's called your death penalty qualified. So jury selection takes on a whole nother layer, as it did in the Parkland case, where each juror is individually questioned about their feelings about the death penalty. And I would not necessarily look at men or women, but again, focus on the issues and how they feel about the death penalty in that lengthy voir dire on feelings, whether you're willing to, it's called death penalty qualification. Do you feel you are qualified to serve on a death penalty case?
So that is just what the parties are doing. That's exactly what they're doing. One juror mentioned his Catholic faith. He said under no condition could he sentence to someone to death. And the state moved to dismiss the juror. The judge granted that. This morning, though, the court did refuse to dismiss one juror, even though the juror said that they were strongly opposed to the death penalty in all cases and would have a difficult time imposing it regardless of the facts of the case. So the state will have to use its peremptory challenge, one of those special hoarded, never want to use one challenges. They're going to have to use that challenge on that juror because that would, at least they'll have to consider that, because that would be a significant problem with the state's attempt to get the death penalty. So the fourth area where there is difficulty in getting a jury is with the knowledge about the case that's already out there. A huge number of the jurors already know something about the case. Let me pull this out. Already know something about the case. And that makes it very hard to figure out which jurors might know too much or even the wrong thing. For that matter, they might even have misinformation. Jurors are supposed to decide the case only on what they hear in the courtroom. So take what happened this morning. 14 of 16 jurors showed up at court this morning. Of the 14, 7 wanted to get out for hardship. And the judge let 6 of the 7 out of jury duty for hardship. The one person he held in was the police officer. And then, spoiler alert, the police officer got dismissed later on in the day. But that left just 8 potential jurors out of the group of 14. So of those, 6 of 8 said they already knew about the case. They said, yep, I've heard of that case. I know a little bit about it. 6 of 8, 75%. So before Lori Vallow Daybell's trial, it was easier. And at the time, here is what Betty said. So let's talk about some of the pretrial publicity issues, because this case has been absolutely sensational. There have already been 2 documentaries on it, at least. So what kind of impact does that have on jury selection? And Rosie Rose, one of the subscribers, and she's on tonight, put it this way, how can you find an unbiased juror when everybody knows about the case?
Well, several things. One, the issue with bias is one of the reasons this case was moved from, I believe it was Fremont County in eastern Idaho to Boise. And the idea being that, Boise is a much more metropolitan area. And even in, you would be surprised how there are people out there that just don't follow the news. But screening for exposure to pretrial publicity in jury selection is typically one of the first things that is done to see what pretrial publicity you have heard, what you know, and whether it will influence you. And yes, we do see, that's why we typically in these cases will subpoena, the court will bring in a large number of people for jury selection, because they are aware that a lot of people are going to be out the door. For example, in Broward County, the Parkland shooter case was tried for a number of months over last year. And you could ask the same question: how could he get a jury in Broward County? And it wound up taking several months. But a jury was ultimately picked and sworn. And jury selection in this case, I mean, obviously they're only anticipating it could go a week, but it could easily go longer until they can find people. But there are people out there that just do not pay attention to the news and aren't familiar with the case, and that's where they'll be focusing.
So in this case, because of the fact, let me make this a little larger, because of the fact that Lori Vallow Daybell's trial has happened in Ada County, it's been even more difficult to find people who have not heard about the case. And instead, the search has become to find people who have not formed an opinion about the case, who at least would be open-minded and ready to hear any evidence that would come in at trial. I have a couple of people I want to thank. Monica, thank you very much. I appreciate your super sticker. And I also want to thank Michael. Thank you. And KS, who lights the dedication and hard work on the cases. Thanks. I really appreciate your watching. And thanks for your super chat as well. One potential juror said that she had a lot, quote, a lot of exposure to the media, and she has a job where her coworkers brought up the case a lot. Now, she said she had an opinion about the guilt of Lori Vallow Daybell. She had also said she had always wanted to be in law enforcement. I'll tell you in a minute why that's sort of an issue for Chad. Now, the defense asked to dismiss her, but the prosecution objected, and the judge let her stay in the pool. She also said she strongly believes in the death penalty. All told, she is, for Chad, one of the nightmare jurors, and he probably will need to use one of his strikes on that particular juror. Now, back at the time Betty was talking to us, one of our subscribers asked a really good question. And Alina Land asked a question. She said, okay, let's say somebody comes in and says, I don't know about the case. How can either side really be sure that's true? What if what they really want is the publicity to write a book, to get on they want on the jury, and they're just saying that?
That's always your risk in any jury trial. People who are I call it test of lying. They are lying to get onto a jury, and it's something as a jury consultant you always have to look for. Do they seem too eager? Do their answers always seem too perfect? It's just something that clear discernment is going to be needed a lot.
So the court is having to go person by person, potential juror by potential juror, to decide these issues. One woman was dismissed this morning because she had seen some documentaries on Netflix about Lori Vallow Daybell. She said she could compartmentalize, but the prosecution moved to remove her, and the defense agreed, and the judge did dismiss her. One man said he knew about the case and Lori Vallow's conviction, and the defense asked if that would shape his opinion about presuming that Chad was innocent. He said, I think it's possible, yes. So the defense moved to dismiss the juror. The state agreed, and the judge did, in fact, dismiss that juror. The court also dismissed a juror who said he had followed social media in the case, and he believed Chad was guilty. So the judge looked at what the person said about what they had seen or heard in social media or on the news, rather than just whether they had ever heard about the case. So let me go to a fifth point. One of the things, and that's law enforcement and knowledge of law enforcement. One of the issues that the lawyers are likely looking for is how much involvement the person had with law enforcement. And I don't mean so much them being arrested, although that would be important, but the state would like to have people with law enforcement contacts and background. Chad would prefer not to. The idea is that they will be more inclined to believe the witnesses who are testifying from law enforcement.
A lot of people often like to overly simplify what a good juror looks like and just focus on things like, age and gender. And that can often create, wrong assumptions, because I would not necessarily assume in any stretch of the imagination that, men would be good or bad, or that women would be good or bad. Women could be sympathetic to a fellow mother, but then they could also, you see a lot of situations where women judge other women more harshly. And so when I'm looking at jury selection, I look more, the research shows that the most important predictor of jury selection is case-related attitudes. I'm going to want to know how people feel about the police system and crimes and criminals and those charged with crimes. And that's going to be what I would recommend should primarily guide decision-making in this case, not a more simplistic evaluation of gender.
So I mentioned earlier a police officer who was in the veneer. That also is pronounced two different ways depending on where you live in the country. But that means the group of people who potentially might become jurors, the people who are showing up and they're going to be interviewed. So the police officer I mentioned ultimately did get dismissed from the case. It was sort of surprising how and why it finally happened. He said he had heard talk radio programs about the case, but he hadn't really kept up with it. Both sides agreed, as they did earlier, and then the judge finally dismissed the police officer on this round. I really think it was kind of more of a matter of he just had so many things come up. I think it would have been a real problem for Chad. He probably would have had to pull out one of his peremptory challenges and use his strike on this witness. So I think that ultimately the judge just said, okay, that's like the third thing or so we've heard about him. I think it's time. Another juror said, well, she was honest to a fault. She would do the best she could to be fair, but being fair to Chad Daybell would be a challenge. And the prosecutor moved to dismiss her. And you might think, well, why would the prosecutor move to dismiss her? That should be the defense. But remember, everybody wants a fair trial. The prosecution wants a fair trial as much as anybody because they don't want to do it a second time. They don't want to have to go up on appeal, get it reversed, and try the entire case over again. So even if you fully believe that Chad Daybell is guilty, you want him to get a fair trial because you don't want him to get one unfair trial and one fair trial. One way or the other, he'll get the fair trial. So the prosecutor ended up moving to dismiss that juror. The defense agreed, obviously, and the judge did dismiss her. Now, the last huge issue in picking is religion. A jury, in this particular case, there's the very delicate issue of religion, because Chad and Lori were members of what most people would call a cult, that they had originally been members of the Church of the Latter-day Saints, that Mormons, but many people would believe they were no longer in that church. They were in a cult of their own. And so I asked Betty about these religious overtones. How do you pick a jury when you know you're going to have a bunch of religious issues in this? What do you do?
Well, there are several issues that you're talking about there. First is, do you want Mormons or non-Mormons? And a lot of that has actually been the Mormon issue has kind of been lessened when the venue was moved from Fremont County to Ada County, which is Boise, because Fremont County was 65% Latter-day Saints and Boise is only 15% Latter-day Saints. So the percent, the likelihood that there would be a Mormon in the veneer would be still, obviously there are going to be Mormons in the veneer, but it will be a lot less. Then the issue is, are Mormons what are they going to think about the Mormon issues? And my understanding is that the defendants in this case were viewed as very much fringe, extreme fringe, and espousing ideas that are not held by mainline Mormons. And so again, it's why we do research. Are mainline Mormons going to judge them more harshly because they are bringing the Mormon faith into ill repute by somehow, justifying what they're doing on some kind of a wacky religious belief that's going to bring their whole faith down? And so again, you don't know how that's going to play unless you do research, but it's something you can think about. You can ask about religious affiliation, and it's helpful to know. And certainly in jury research that I've done, I've seen instances where religious affiliation of one stripe or the other has correlated with a verdict. And so you just have to ask it delicately. And the other thing that can be helpful, again, if you're doing research and you kind of know whether it matters, is not religious affiliation, but religious activity, like involvement. How often are you attending religious services? Do you read religious sacred text, such as, the Bible, the Quran, or things like that.
And, I don't know that there's any major issue that was left out of this trial. I still believe that this is a really complicated case with overtones of all kinds of third rail issues, as I would call them. So what would the perfect juror be? What would the defense, if the defense could create a juror exactly like they wanted, the prosecution could create a juror exactly like what they wanted, what would they be looking for? What are the factors? So I asked Betty that question. Pick a gold medal juror for the prosecution and a gold medal juror for the defense. Tell me about that juror.
Again, what it's going to be is case-related attitudes. And a lot of times, if what happens is, jury selection is not a process of selection, it's about deselection. And what you're trying to do is ultimately to figure out who the best jurors are for the other side. And so while you could identify a gold medal juror, I'll first immediately tell you that person, if any attorney's doing their job, is not going to be on the panel. It's going to be the non-gold medal jurors. Right. But when I'm looking at a gold medal juror for a prosecution, I'm obviously looking for someone who's, pro-police, anti-criminal, maybe been a victim of a crime, very trustworthy of police investigations, of police officers as witnesses. Though again, you're looking for those case-related attitudes. Maybe they think that the law coddles criminals to the detriment of society. Things like that. They're going to agree with these, pro-police, pro-victim, sentiments. And though, that's a gold medal juror. And then also, somebody who has those sentiments who is also a leader, because again, leaders are going to lead. And if you've got somebody with sentiments who are that strong pro-prosecution, who's also a leader, that's your gold medal. Same thing for the defense. You're going to basically flip those questions, and you're going to be looking for somebody who is suspicious of police investigations, doesn't necessarily trust DNA evidence, somebody who maybe has, had themselves or family members been charged with crimes, or maybe unfairly charged with crimes. And again, to the extent that person is a leader, is going to be even more a defense-oriented person.
So there you have it. That is what Betty told us before Lori Vallow Daybell's trial. And I think it basically held true. And I do think that this has become an even more difficult case for picking a jury, for selecting a jury that can be fair to Chad Daybell, and everybody needs that to happen. So go ahead and put your questions in the chat, if you would. I'll be looking over there to see what questions people have. And meanwhile, I want to thank Irish Twins Mom. Thank you. I appreciate the super sticker very much. So let me pop over to the chat and see what questions are coming in. Deidre Steele wants to know, do you think the judge is being cautious? Example, he's keeping panel members who say they want to start with the death penalty, but then say that they can fairly consider other choices. I thought his one decision about the juror today who said that they really couldn't do the death penalty, I thought, I was surprised he didn't strike that juror. But those people will probably be struck, and they're obviously doing as good a job as they can, and everybody's working on it pretty hard. So I think that, but are there individual problems? Maybe. It could be individual ones, probably not enough to taint the entire jury. But when you have a death penalty case, everything matters. Every little thing matters. Okay, so, and Tracy is asking me, did they keep the juror who is against the death penalty? I know she said she could, there were several who had issues about that. I know she said she could listen to the evidence and make a decision based on, but she was so firm in her beliefs. That's what Tracy is asking me. So Tracy, I don't know exactly the one, because there were a number of jurors who talked about their death penalty opinions. Some who said I couldn't do it at all. Some who said I could try to put my feelings aside, but I'm pro death penalty, or I'm against the death penalty. And it was maybe a little inconsistent as far as which ones got dismissed and which ones didn't. Probably the judge had some good, consistent reasons for all of that. But sometimes it did seem to an outsider like maybe one seemed like, wait, I thought that met the standard from the other one. But these are really close questions. A lot of judges would pass through anybody who will simply state the words, oh, I will try to be fair. If someone will state that, they'll pass them through. So that's not necessarily enough reason to strike somebody. In a death penalty case, it's more of a reason to strike somebody than anybody else, because it is so, it's so hotly contested on appeal, and the appellate courts look very, very hard at those cases, as they should. We're talking about actually taking someone's life. So obviously it has to be done properly. It has to be done with safeguards. It has to be fair. So those are all the things they're going to be looking for. Irish Twins Mom wants to know whether attorneys have access to potential jurors' names so that they can do their own research about jurors before they see questionnaires. I understand that they do. And also they talked today about the fact that the prosecution has criminal investigation files on these jurors. So they know if somebody has a criminal record, or at least an arrest record, and what it was for. And they were sharing that with the defense, and they were saying, we can't give you a copy, but we can share it with you. They could only have done that if they had the names, would be my guess. I also had heard that they had done some investigation and that they had some information written down about what they had found. There was an investigator sitting behind Chad Daybell and behind his attorney, John Pryor, sitting right, who works with them and apparently had done some work on the jurors. That is something that is so different in different courts that you go to. I mean, I've been in little bitty towns where you would literally bring in somebody who would talk to you about who these people were. They knew all of these people, and they would say, oh yeah, you don't want Jane because her mama is, related to so-and-so, and the two of them have been thick for a long time, whatever. There would be a real detailed information. And then in a lot of places, you get nothing. You get a number for the person, you get no name, and you have what happens during the interview of the juror, and that's all you get. So it is really different. I'd be interested for those of you who are attorneys or paralegals, tell me what your experience is in the chat or the comments. Have you had it both ways, or how does it done most commonly in your area? All right, so I'm looking for the questions. Here's Annie K. Is John Pryor, Chad Daybell's attorney, trying to get so many prospective jurors off because he's limited later to remove them? He seems adamant that they all have reasons to be off. Yes, Annie K. That is the name of the game. That is exactly why it all happens and why it's done. And so everybody is trying to get as many jurors who might be negative for them off as possible. And then they don't have to use up those challenges. You're hoarding those challenges. You're keeping them until the last minute. You never have enough. So those are very precious, and you want to save them for people that you just desperately have to get rid of. Okay, so, see, Magic Lady gifted 5 lawyerly memberships. Thank you, Magic Lady. I so appreciate that. People really enjoy that. And we've been having such a great time. Let me go ahead and put that up on the screen. We've been having such a good time with the emojis and things that we can use, and people just enjoying that in the chat. So thank you. I really appreciate that. A membership, in case you're wondering, is a way to financially support the channel. You can watch a video anytime. You can subscribe. That's completely free. And then YouTube will mark in its little memory that you like the channel, and will show you, if you turn notifications on, it'll send you a notification whenever we go live. Miss Construe wants to know, is a parole officer considered a court worker? Can I get off jury duty because you talked to your neighbor? I don't know, Miss Construe. That might be a little hard. I'm not sure that would, just talking to a parole officer would be enough. I'm thinking that's probably not enough. So you'll have to come up with something a little stronger than that, I think. Although I'm sure you desperately want to serve on jury duty, right? Tennis Girl. Do the other potential jurors hear the responses of the person being questioned? Like when some come in and they think Chad is guilty. I think so, because they talked about if a juror was selected, that person went up and sat down. And it sounded like they were still in the courtroom. We don't actually have a visual on the jurors, so I can't say that for absolutely sure, but that's what it sounded like. I was kind of surprised by that too, that they weren't sent back into another room, but it sounded like they were hearing what was being said, including if people said they thought they couldn't be fair, that sort of thing. There are at least sometimes when the attorneys and the juror will speak privately, at least that's normal, that there would be private conferences too about something more sensitive or more personal. That would not be something that people want to talk about in the group. Michael asking, how does the members badge system work? Michael is saying his badge is red and wants to know when it changes color. It changes at 1 month. We've had memberships for about a month. I think it changes to blue. I think it starts off red and then it changes to blue after 1 month. And then it changes again periodically. I think every month, or again on the 3rd month, and then 6 months and a year. So Marlon did for us a whole slew of these emojis that look like the gavel to show membership. So that's going to be a lot of fun too, watching those change. And some of them are a little bit different. Like if you've been a member for a year, there's a super special emoji that you get. And emoji is probably the wrong word. Badge, that's my word. Eileen wants to know, Lori didn't want to cast shade on Chad in her trial. Do you think Chad will blame Lori for what happened? Yes. Yes, I do. I do think that is exactly what his plan is going to be, or at least his attorney's plan. And will he testify? I don't know about that. I asked y'all what you thought, and something like 60% of you thought, I'm trying to remember now, did 60% of you think he would and 30% think he wouldn't, 35, 65? Well, I have to go back and check. I can't believe I've forgotten which way that went. But I don't know that he will testify. I'm kind of inclined to think that he will, but that is obviously not the thing normally advised. So I wouldn't be at all surprised if he elected not to. If he can possibly avoid it, obviously he would. But I do think the plan will be to say Lori will take the blame. That was even one thing that I talked about with Betty back when we did our interview was the fact that Lori and Chad had split apart and were no longer going to be tried together, which was the original plan by the state. And the fact that that was no longer the case meant that she felt like would be a little bit easier for them to blame each other, that would be, and it made the case easier for both of them. Lori didn't take advantage of that. She didn't even put on a case, not even a witness. So there was no real attempt to blame Chad, whereas I think it will be different in this particular case. Okay, let's see. I think that's the same question I already answered. Mark Harris, is it fair that Chad faces the death penalty when Lori didn't, although it's the same case pretty much? Mark, that is a really good question, and obviously one that Chad Daybell's attorney asked as well, and said, even did a motion saying that's really not right. You've made the decision that she didn't get the death penalty, so he shouldn't. But the reason she did not get the death penalty was not because of the fact that she didn't deserve it. It wasn't because the prosecution wasn't asking for it. It was related to a decision the judge made because discovery had not been produced in time for her to review it. There was information that had just come in and she didn't have time to review it. She had invoked her right to a speedy trial, which Chad waived. He said, I'd rather take my time before trial. I don't want to waive. I do want to waive my right to a speedy trial. I want to wait. She wanted to go ahead and have her trial. So they ended up separated. And just because of the fact that this information came in so late, the judge said, this is a discovery problem, and I'm going to I'm going to remove the possibility of the death penalty. That didn't happen for Chad. You could also argue he has an additional murder charge, which is Tami Daybell, whereas Lori had, I think I'm right about this. I think Lori had a conspiracy on Tami, but not a murder charge on Tami. So I think that may be another issue too. There are some differences. I don't think that that's going to be something he wins on appeal, but there is a fairness element to it. It doesn't seem right if they did the same thing, that one is treated one way and the other is treated another way, but it wasn't because of anything that was related to a difference in what they did. It was because of this discovery issue. So, Scooter, what do you think John Pryor is looking for in a juror? I think John Pryor would love to find people who don't know about the case. I think that's going to be really difficult. And I think it's also going to be hard for him to find people who have zero opinion on the case. So if he had the ideal juror, he definitely would want somebody opposed to the death penalty, who had never heard about the case, who was suspicious of law enforcement and believed that law enforcement was, out to get people, I guess, something like that. So that would be a good juror for John Pryor. Okay. And I have some more people to thank. Let me make sure that I do. So thank you, Paige. I appreciate that. Lawyerly membership. That's a lot of fun. I really do appreciate y'all doing that. Cheryl Brady. And in case you're wondering, how do I get the Lawyerly membership that was a gift? Because they're available. You have to go down to, there's like a rectangle with a dollar sign in it. Maybe in your country you have a different sign. But anyway, I think it'll be a dollar sign for most of you. And you will click on that and it gives you an option of accepting gifts, something like that. So, and maybe Marlon can put a little bit more in the chat to fix whatever I got wrong with that sort of botched explanation there. Okay, Atticus. Oh, thank you. Atticus is enjoying the questions, the answers, the interest, and the mods. We love our mods. We have Marlon and mamapinks who moderate for us night after night and make it such a nice, pleasant place to be. We are very, very fortunate to have them. And Atticus is saying they love learning something new every single day. Highest possible praise to everyone. What a nice note. My warm gratitude as well. Well, thank you. Thank you, Atticus. That was really nice. So let's head back over and answer just a few more questions. Gabby wants to know, do you think John Pryor stayed on this case as a sole attorney to give Chad the opportunity to file an ineffective counsel reason if he's found guilty? I don't think so, honestly, Gabby, because I think he wanted help. He tried to get help, and they could not find a death penalty certified attorney who could help him. It's pretty hard to get certified. The person has to have actually had a trial to be like a lead counsel for a death penalty case. And I think he asked for one, the judge approved it, but they couldn't find one. They literally were unable to find them one, according to what he said in one of those hearings, right, shortly before trial, in the months leading up to trial. May have even been December. So I think he would have liked to have had help. I think he needed help. I think it would be extremely difficult to do a trial this long all by yourself. I can't even imagine how exhausting that would be. And on top of that, a death penalty case, really, really exhausting. This is a very hard thing to do by yourself. CS, just how invasive can questions to the prospective juror be? It depends on the case. For example, if the case involved mental health issues and that was an important issue in the case, then you could ask about mental health because it mattered. It might be done privately, discreetly, just the juror, just the lawyers, just the judge, nobody else allowed. But if it was an important issue in the case, you'd be allowed to ask about it. On the other hand, if it has nothing to do with the case, you can't ask about that. So it's going to depend on the facts of the case and, of course, what the judge allows as well. Diane Dills wants to know, don't you think after jurors see the crime scene photos from Chad's property, some jurors might lean a lot more to the death verdict? I think the judge is banking on that, Diane. I think the judge is thinking when a group gets together, they see collectively the evidence and they agree with each other that they are going to do their best to work together to come up with a verdict, with a solution. Just one disagreeing takes the death penalty off the table. But I think the judge is thinking, I can let some of these people through because as a group, they'll work together and pull each other along to make a fair, good decision, knowing that they have to make a decision in favor of the death penalty if the appropriate standard is met. If that happens, that's what they're supposed to do. That's what they'll be told to do under the jury instructions. Okay, I'm looking, Victoria asking me, what about prospective jurors who are disabled? If you might, I'm not sure which direction you mean. If you mean about getting to the courthouse and that kind of thing, that can be a real problem. We had that issue here. My husband is disabled and he wasn't able to get to the courthouse. They had a shuttle bus. You were supposed to park in this distant parking lot. They had a shuttle bus. It wasn't handicap accessible and things like that. So sometimes it can be a real problem for jurors to serve. And one of the solutions the court makes is it says, okay, you don't have to serve if you're disabled, which isn't quite the same thing. If you wanted to serve, then you don't have that opportunity. Fortunately, it's not a real common issue, but it definitely happens from time to time. And that might be what you were asking, or so that's my guess. But if it was something else, Victoria, put it in again with a little more detail, and I'll try to figure out what your correct answer would be. Cheryl asks how many they get to strike. So my understanding was they each are going to get 18. And Stella wants to know, so are the 16 already fully selected or do they move to another section and go through more examination before being fully on the case? So here's what I think, Stella, based on what we've heard. I think they have been moved to the group they've been accepted. There have already been the motions related to whether or not they can serve on the jury. That's already finished, and they've already been asked all their questions, and now they're in the group of 50. They're only at 20 of 50, but one day, by the end of the week, hopefully they'll be at 50. And that's when everybody can use their strikes, and there will be the 12 selected plus the 6 selected. So they're waiting for that moment and that time. Okay, so I am looking to make sure that I gave you the correct number the correct number of strikes that they're allowed. I think, didn't I say 18? I'm getting tired. That's a sure sign that I need to stop answering questions pretty quick, but I think I said it was 18. Yes. 16. No, it's 16. Sorry, there's your answer. 18 jurors, meaning 12 jurors, 6 alternates, and then 16 challenges or strikes state, 16 challenges or strikes defense. That's what I had written down. Okay, so let's see who else. Beth A., can you think of any significant difference in an ideal juror for Chad versus for Lori? You know, Betty was not a fan of considering gender issues. I think sometimes gender issues can make a difference. So I think that can make a difference. I think for Lori, but she was saying that it can be hard to predict based on gender issues what exactly it is that is important. The fact she pointed out that a mom is on the jury, they could either be super critical of Lori or they might relate to her in some way and say, well, she couldn't possibly kill her children. How could a mother ever do that? I don't believe it. And so it could work either direction. That was what her point was. But I can certainly see where there could be some gender issues here, and that I can see where women might be a better bet on the jury for Chad than they would have been for Lori. That's just a theory. Who knows? Okay. Thank you, Toe Beans. And is prior death qualified? He is not. He is not. This is his first death penalty case. He is not death penalty qualified. No. And Diane, thank you very much for the super sticker. I appreciate that. All right. So last question. We're going to head over here and get to the last question. We've already answered that one. So Christy wants to know how we get the emojis, and it's by being a member. That's how Marlon did all those emojis for us. So they are super cool. And you can use them anytime you're commenting or in the chat on the channel. They're really awesome. Okay, look. Oh, here we go. Bisky. Ask from what country people are from. That is always so interesting. Do you know that about 25% of you are not from the US, which is fascinating to me, just absolutely fascinating. So definitely put in the chat or the comments, where are you from? I'm always so curious to figure that out and find out where you are from. And so I think we have about hit the end of it. I still see some more. Patricia Christmas asking me, is religion also covered by Batson? If they decided they didn't want a Catholic or a pagan on the jury, well, thinking of the Delphi case, would they be able to strike the prospective juror? The last time I researched that was right before the Lori Vallow Daybell trial, because I wanted to know that. Betty's understanding was you can ask about that. And I don't think it would be covered by Batson. I don't think it's specific to Batson, but she thought that was her opinion at the time. She didn't think it would be covered, but it was sort of evolving, I felt like, that whole issue. So I don't know what it would be, and it would need to be updated. If anyone knows for sure, stick that in the chat. I'd be curious for that. So we will be going live tomorrow night at 7 for our usual customary time, and I will look forward to seeing you then. Prosecution showed it to jury, and so you can get a pretty good look at it too. Red, blood-like substance on it. He said it was even wet and leaking everywhere. That was a quote. Zip ties, a razor blade. Why were they? I hate it when I do this, but would you please hit the like button and subscribe? Love to have you back. And thank you, Sue Candle, very much. These items there. And in the back window is a bobblehead of Alec Murdaugh going back and forth.